Trial resumed. Jury not present.
The court said, "Good morning. Please make your appearances."
Ms. Murray said, "Good morning, Your Honor." Juliana Murray, Ryan Finkel, and Justin Horton, on behalf of the United States. We're joined by paralegal specialist Isabel Loftus and Special Agent Robert Stout.
Mr. Kamraju said, "Good morning, Your Honor." Siddhartha Kamraju, Sabrina Shroff, Scott Skirick, and Matthew Barkin. On behalf of Mr. Gua. And Mr. Gua is with us at counsel table.
The court said, "Please be seated. I received a second note from the jurors at 9:19. It's dated today's date. It's signed by the foreperson. I'm making it Court Exhibit Number 2. States we, the jury, request the hard copies of GX79 we received in the black binders early in this trial. Also, a hard copy of GX417T. I'm sorry, GX9 is the first item, so GXE9 is one item. But the transcript of GX417T, that's a binder that has other items in it. And so my question is, would you want me to send back the whole binder or just GX417T?"
Mr. Kamraju said, "I think we should send back what they ask for, Your Honor."
Mr. Finkel said, "Your Honor, these are transcripts they have electronically. So sending them more of them in a hard copy, I think would just make things easier for the jury. It would be easier for the parties, and Your Honor's staff as well, since they're already put together in a binder, which they've already been provided. So the government's view would be to just send back both sets of the binders. The Z9 binder, which I understand your court staff has, and the 400 series binder, which includes 417T.
The court said, "So the one that contains GX417T also contains GX404T, GX405T, GX406T, GX408T, GX409T, GX411T, and GX412T and G times 413A-T.
Mr. Finkel said, "Your Honor, on further reflection, hearing all those, if the court's preference is to just send back 417T, it won't take us very long to print those off, and we can do that instead, just to avoid an issue, frankly."
The court said, "Understood. Yes, it would be simple just to send back the GX417T.
Mr. Finkel said, "Your Honor, we're going to print them right now, bring them up. So we don't have to break apart the binders, which would take more time actually, I think. We'll just print 417T. Bring them up."
The court said, "All righty. Go ahead."
Mr. Finkel said, "We're doing that now. It will take a few minutes. One other item, Your Honor, that came to our attention last night, if Your Honor is ready for a different issue. I don't know if this is really an issue. I guess it's really more for the defense. But in an abundance of caution, I just wanted to raise it with Your Honor, and the court with Your Honor, and the defense. Upon reviewing the transcript last night, during the charge, this is at page 5787, and I have hard copies. If the court would like, when discussing the government's burden and what is reasonable doubt, Your Honor, according to the transcript, said, if you have reasonable doubt as to the defendant's guilt, you should not hesitate to find the defendant not guilty. But on the other hand, if you find that the defendant has met its burden of proving the defendant's guilt beyond a reasonable doubt, you should not hesitate to find the defendant guilty."
The court said, "So I specifically remember that misstatement and then going back and saying, 'Government, does the defense concede that that is what I said?'"
Mr. Kamraju said, "Yes, Your Honor. We're fine."
The court said, "Okay."
Mr. Finkel said, "Thank you."
The court said, "So I will ask that the transcript be corrected."
Mr. Finkel said, "Thank you, Your Honor."
The court said, "So we still have the issue of the first note. My sense is that the second note is a clarification of the first item requested in the first note. Do you agree?"
Mr. Kamraju said, "That was my impression, Your Honor."
Mr. Finkel said, "Government agrees."
The court said, "Okay. So then the issue becomes then what about this restatement of the limiting instruction?
Mr. Kamaraju said, I think we should ask them. Because I think there are a number of limiting instructions that Your Honor gave over the course of the trial. I think some of them were different, and I think they have different import. So I think we should just ask the jury to be clear as to what they mean by it.
The court said, okay. Let's have the jurors brought in.
Jury present.
The court said, please be seated. Good morning, jurors.
The jury said, good morning.
The court said, when we stopped yesterday, I read out loud the note that I had received from you. It contained 2 requests. The first request was physical copies of transcripts. Then this morning at 9:19 a.m., I received a note stating, the jury, request the hard copies of GXC9 we received in the black binders early in this trial. Also a hard copy of GX417T. Those, I believe, are the transcripts that you were referring to in the first note. If I'm wrong, then you'll send me another note. With regard to the second request from yesterday, restatement of limiting instruction, I need more details about what it is that you're requesting because I don't entirely understand the request. I will need that in a note, so you'll go back to the jury room.
Jury not present.
The court said you may be seated, so I'll let you know when the second note of today comes.
Mr. Kamaraju said, thank you, Your Honor.
Recess pending verdict.
The court said, please be seated. I received a third note from the jury at 10:49 a.m. I'm making it court exhibit number 3. It's signed by the foreperson. It has today's date. States we, the jury. One of the jurors disclosed they had Googled William J. this morning. How would you like me to handle this?
Mr. Kamaraju said, could we just have a moment, Your Honor, to confer?
Counsel conferred.
Ms. Shrofa said, Your Honor, I apologize. Could the court reread the note, please?
The court said, sure.
Ms. Shrofa said, thank you.
The court said, it states, we, the jury, one of the jurors disclosed they had Googled William J. this morning.
Ms. Shrofa said, thank you, Your Honor.
Counsel conferred.
The court said, the most recent case that we've found on replacing a juror for good cause because of juror misconduct is United States v. David Delva, 858 F.3d 135.
Mr. Kamaraju said, Your Honor, I'm sorry. I wasn't sure if you were done. Ms. Schroff and I actually dealt with this in US v. Schult. And the way that we handled it there, or Judge Crotty handled it there, was I believe the court made an inquiry of the foreperson as to what was the sort of disclosure. You know, whether the person told any of the jurors what they found on Google, and which juror it was. Since we obviously don't know strictly from the note. So I think that would the next step. Would be to have an inquiry on the record with the foreperson to see what information the parties can get. Obviously cautioning the foreperson not to disclose anything about deliberations that the jury is having.
Mr. Finkel said, can we have 1 moment to review the case and want to respond?
Ms. Shrofa said, Your Honor, the note says that one juror informed that they had Googled William J.
The court said correct.
Ms. Shrofa said, so it's unclear if there was any follow-up, right?
The court said correct.
Ms. Shrofa said, I just can't tell from the note how far the taint into the jury venire, the jury, the 12 jurors has gone. May we just have a slight break so we can figure out how?
Mr. Kamaraju said, I think we should ask the foreperson.
The court said, I'm sorry?
Mr. Kamaraju said, could we just have 2 minutes?
The court said, a couple of minutes.
Counsel conferred.
The court said, please be seated. I'm going to hear first from the defense.
Mr. Kamaraju said, Your Honor. I think we would adhere to our proposal that I think Your Honor should question the foreperson first to, 1. Identify which juror made this disclosure, and, 2. Understand what the extent of the disclosure is. During that inquiry I think Your Honor, as naturally would, should at the beginning caution the juror to not disclose anything about the deliberations. And limit their answers to specifically the disclosure about the Google. And I would propose that inquiry should happen not in the box, but in the robing room.
Mr. Finkel said, so, Your Honor, Obviously, it's unclear exactly what the information is. They have the indictment right, which names William J. They've obviously heard about him. So if it's well, we don't necessarily oppose what defense counsel has proposed. We certainly agree that any inquiry of the court seems to be another note.
The court said yes. If you'll just finish your sentence.
Mr. Finkel said, I was going to say, we agree the inquiry should be limited. We provided a case cite to your clerks and to defense counsel, USV, Farhane, 634 F.3 D 127. And it describes about the court's broad discretion in how to handle these sorts of issues. And so largely this is within your Honor's discretion. Certainly there does not seem to be any taint. Based on the content of the letter, they seem to be very specific about it.
The court said, so I've received another note from the jury. It's from 11:16 a.m. I am making it court exhibit number 4. It's dated today's date and signed by the foreperson. It states, we, the jury per last note. We have stopped deliberations pending instruction. Should we continue to pause or may we resume while you review? So I'd like to call the foreperson into the robing room, along with counsel.
Mr. Kamraju said, thank you, Your Honor. Your Honor. Did you want Mr. Gua to be back there?
The court said, are you making that request?
Mr. Kamraju said, no, Your Honor, we weren't. We weren't. The marshals just asked. We're not making a request.
The court said, okay.
In the robing room. Foreperson present.
The court said, at 10:49, I received a note from the jury. Says we, the jury. One of the jurors disclosed they had Googled William J. this morning. And it's signed by the foreperson and dated today's date. And I made it court exhibit number 3. We have with us the foreperson of the jury, juror number 1. I received another note at 11:16 a.m. It is court exhibit number 4. Also signed by the foreperson dated today's date. States, we, the jury per last note. We have stopped deliberations pending instruction. Should we continue to pause or may we resume while you review? So first I want you to listen to my questions very, very carefully and only answer what I'm asking. Above all, I don't want you to state anything about the deliberations, where you stand, for example, as to whether or not the defendant is guilty or not guilty. You understand? Foreperson, yes. The court said, all right. My first question is which juror? Foreperson, number 2. The court said, okay. And you say that he stated that he had Googled William J.E. Did he state anything further? For example, about what he had found out? Foreperson, the court said, did he state anything beyond the fact that he had Googled William J.? Foreperson, she stated why she did it and that was it. The court said, was everyone? Were all the jurors in the room at that time? Foreperson, yes. The court said, and from your observation, do you think that everyone heard that? I know it's impossible for you to say what someone else heard, but based on your observation? Foreperson, yes. The court said, okay. I'm going to excuse you for now. I don't want you to discuss what we have discussed. Foreperson, okay. The court said, all righty.
Foreperson not present.
Mr. Finkel said, Your Honor, you should instruct the foreperson to not continue deliberations while we continue this. Paused. Time.
The court said, I think that they have said they've.
Ms. Shrofa said, right.
The court said, so I propose bringing in number 2 at this.
Mr. Finkel said, Your Honor, to the extent I may, to the extent Your Honor feels it appropriate. Obviously, it's within Your Honor's discretion. I think one question for juror number 2 back to it. To the extent Your Honor feels it appropriate to ask, whatever juror may second a scene. Obviously, could be any number of things. The question is whether the juror can place whatever they saw out of their mind and just focus on what is evidence at the trial. Just consistent, of course, with Your Honor's general instructions. The government thinks that would be an appropriate inquiry at this point.
Ms. Shrofa said, no.
Mr. Kamraju said, so obviously.
Ms. Shrofa said, that's not the.
Mr. Kamraju said, sorry. Obviously it will depend on what is said. But there is a more fundamental question of the juror disregarding the court's instruction not to Google or do any outside research, which is independent from their ability to set aside whatever they found. So I'm not proposing any course of action now. But I am saying there are two distinct issues here that we're going to have to deal with.
Ms. Shrofa said, "Actually, I think there are three, Your Honor."
The court said, "I see a third issue."
Ms. Shrofa said, "Right."
The court said, "A third issue is."
Ms. Shrofa said, what she said to the jury about why she Googled William J. That's the biggest question. The question is how far the taint goes into the jury. This should be I'm sure the court knows this. The first step is just to ask her what is it that she said to the entire jury pool and stop there. Because I personally, given her answer, would like to talk to an appeals lawyer before I take the next. I think the most important question isn't what she did. The first question is what she said to the jury about what she did. This isn't just about what that particular juror.
Mr. Finkel said, "I understand that. Obviously, we should see what she says. But the ordering is important here. She explained why she did something, not the result of what she had done."
Ms. Shrofa said, "You don't know that."
Mr. Finkel said, "Can I please finish, Ms. Schroff? You're right, we don't. We need to see what she says. But please, just please, thank you. It would be different, and we'll see what she says. But it's obviously different if juror number 3 said, and apparently did not juror number 2, said, apparently did not, I Googled it and, as a result of what I Googled, I believe this. She said, we were discussing something in here, and because of that I Googled something. And it appears the rest of the jury said, stop. And the jury did the right thing. So I think that's important. And we'll see what she has to say, and the government will evaluate."
The court said, if she said more than I Googled William J.E., then there's the question of what impact did that have on the 11 other jurors.
Mr. Finkel said, absolutely, Your Honor. But if she said?
The court said, in other words, I don't see how I cannot interview every single juror.
Ms. Shrofa said, that's correct.
Mr. Finkel said, we have to see what I think she said first. That would be the government's proposal, Your Honor. For example, if she says, I saw that William J. was charged in this case, they know that. He's on the indictment. So there would be no prejudice there. So it depends what the information is.
The court said, so there are two pieces, what did she see, what did she learn? And number 2, what did she say?
Mr. Finkel said, the government agrees. The government agrees.
Ms. Shrofa said, I just think the order is the opposite. What she told the jury is more vital than what she saw or what she comprehended. The first question, the court is correct, is what did she say to the jury as to why she Googled William J. And then I think every juror must be questioned. I can't imagine that taint should not be explored.
The court said, I don't think we should assume that he has adequately characterized what happened.
Ms. Shrofa said, oh, that's true.
The court said, I think I should first ask her whether she made any statements concerning William J. I think that's where I have to start.
Mr. Finkel said, it would be about the Google search though. Of course they are talking about.
The court said, about the Google search, yes.
Mr. Finkel said, thank you, Your Honor. Juror present.
The court said, hello.
Juror said, hi.
The court said, you're juror number 2, right?
Juror said, yes.
The court said, I want you to listen very, very carefully to my questions, and only answer the question that I'm asking. Understood?
Juror said, yes.
The court said, did you say this morning in the jury room that you had Googled William J.E.?
Juror said, yes.
The court said, did you state what you had learned? This is a yes or no question. Foreperson, yes. The court said, and what is it that you said? Foreperson, because the indictment mentioned also William J. Frankly, I just wanted to know if there was also a case on William J.E. So what I told them was that, I said, well, this case also involves William J.E. So we are, it's because there was one person. The court said, well, no. I can't have you discuss anything that was said by somebody else.
Juror said, okay.
The court said, I am concerned about what you said to the others.
Juror said, I just told them that I wanted to know if there was also a case against William J.E. And I said that I did Google his name, and that there was also a case against him. That's all I said.
The court said, that's it?
Juror said, that's it.
The court said, that you Googled William J.E. There was a case against William J.E.
Juror said, yes.
The court said, okay. You may step out.
Juror not present.
The court said, okay. So I did not ask whether she could put aside what she learned, because I wanted to first ask whether you want me to ask any additional questions before I go there.
Mr. Kamaraju said, I think it would be helpful to know when she conducted this Google search.
Ms. Shrofa said, and when she told the jurors, just so that we have that clear on the record, if the court wants. But, Your Honor, I think she mentioned before the last two answers as to why she Googled William J.E. So I wasn't clear if she also shared that information with the jury as to why she Googled him.
Mr. Finkel said, so?
Ms. Shrofa said, because we cut off the answer, rightly so, but maybe there is a more precise or narrow way to ask why she did it.
Mr. Finkel said, the government has no objection to the two questions. When she Googled it, and what time she told the jury approximately. I think those are fine. The why question seems to go into their deliberations. And I think Your Honor appropriately cut her off. The why seemed to be a response to something that was happening in the jury room. That's my take on it. I obviously don't know. It also seems that what she learned is not anything different than information that they have. Because they have the indictment, they know William J.E. was charged.
The court said, so I did not get the impression that the reason had to do with something going on in the jury room. It seemed to me that it was her individual question about William J.E. She certainly didn't identify that this was part of their discussion. And I do agree that the only question is when did she do the search and when did she tell the jurors. Would you have her come back in?
Ms. Shrofa said, Your Honor, would the court consider asking if the jurors deliberated between the first and the second note?
Mr. Skirik said, in other words, is it clear that once juror number 2 said what she said, that they paused deliberations right away?
Ms. Shrofa said, because there was a slight lapse.
The court said, okay.
Juror present.
The court said, so once again, I caution you to just answer the question that I'm asking. When did you do the Google search?
Juror said, this morning.
The court said, what time?
Juror said, 6 in the morning, more or less.
The court said, when did you tell the other jurors that you did the Google search?
Juror said, like half hour ago, 40 minutes ago.
The court said, so right now it's 11:33. You think that you told them around 11?
Juror said, I didn't look at the time, but it was right when they sent you the note.
The court said, and when you told them, did the jury continue deliberating or was there a stop at that point?
Juror said, they stopped.
The court said, okay. Thank you. You can step out.
Juror not present.
The court said, so I think at this point the appropriate question is whether she can set aside anything that she may have learned about William J.E. Agreed?
Ms. Shrofa said, no, Your Honor.
Mr. Finkel said, yes, Your Honor.
Ms. Shrofa said, I think the fact that she has broken one of the rules imposed by the court, and a rule that the juror is supposed to follow, I think that necessarily means that she cannot continue as a juror. I'm happy to take some time and do the research, but I think a juror who breaks the court's rule, and I believe that's what happened with Schultz.
Mr. Kamaraju said, that was Judge Crotty's ruling.
Ms. Shrofa said, the moment somebody breaks a rule, I don't think they can continue deliberating as part of the jury.
Mr. Finkel said, so, Your Honor, we provided a case cite to your staff and also to the defense. It's U.S. v. Farhane. provides that the district court has broad discretion in how to handle this matter. I just read this case. So if I have a fact wrong, please forgive me. But I think what happened in that case was a juror Googled a co-defendant or a co-conspirator and found out they had pled guilty. Which was information that, as it turned out, the defense had made a point of in their closing. In other words, it was information, and again, forgive me if I have a fact wrong, I'm sorry. It was information that the jury knew. So there was no harm, no prejudice, and the conviction was upheld. Given what we know, which is juror number 2 Googled William J.E. and found out that he had been charged, and that information is known to them because the indictment was sent back to them, which lists William J.E. was sent back as agreed by the parties. The jury stopped. There was no further deliberation. I think the only remaining inquiry that would be appropriate, this is the government's view, is to say to juror number 2, can you follow my directions? Are you going to follow my directions and put out of your mind, as your honor suggested, whatever you may have seen? And if the court is satisfied in your honor's discretion that juror number 2 can do those things, the government's view is that the court is on firm ground to continue.
Ms. Shrofa said, Your Honor, may I? So United States versus Farhane was an Eastern District terrorism case. In that case, the co-defendant's guilty plea was part and parcel of the record, as I recall it. Here, William J.E. is being charged, was not front and center before the jury. But put that issue aside. So far, the questions that have been posed to juror number 2 do not include what else she found out during a Google search. So far, the record indicates what she shared with the 11 other jurors after she did the Google search. So at the very least, this court would have to inquire whether or not she read anything more about William J.E. Then take the next step and inquire whether or not that would impact her thought process. And then do the reassurance step that the government suggests. There is zero argument from the defense side that this court does not have wide discretion. Of course, it goes without saying this is all within the court's discretion, 100%. How that discretion is exercised, though, is what we're talking about. And it would be the defense's position that the inquiry has to be a minute step-by-step. And a juror who disregards direction and conversation is curtailed by the other jurors would be a juror that should be replaced.
The court said, but is that your application? Is that the application of the defense?
Ms. Shrofa said, Actually, we haven't. I'm just trying to think through the steps. I'm not really.
Mr. Kamaraju said, I think before we make that application, Your Honor, I think it does make sense for the court to inquire as to what else she saw.
Ms. Shrofa said, or read.
Mr. Kamaraju said, or read.
Ms. Shrofa said, and frankly, I'd like to talk to an appeals lawyer.
The court said, well, we don't have time for that.
Mr. Kamaraju said, would propose, which I think the government is on board with, I would propose starting with that. Is just asking her, and I understand that if I'm going to move to replace her anyway. Maybe that is a pointless step. But I think for the record purpose, at least, it makes sense to get that information out.
Mr. Finkel said, Your Honor, just if I may make 2 points. 1, no objection to the question of what, if anything, else she learned, aside from the fact that he was charged. And 2, just to note, Farhane is a Second Circuit case. That's what I was referring to. It was, I guess, in the Eastern District, the trial court. But it's a Second Circuit case.
The court said, would you have her brought in again?
Juror present.
The court said, so you said that when you Googled William J.E., you found out that he had been charged in this case?
Juror said, yes.
The court said, did you find out additional information about William J.E.?
Juror said, no.
The court said, there's nothing other than the fact that he was charged that you learned from your Google search?
Juror said, no.
The court said, in other words, yes, there was nothing else?
Juror said, yes, there was nothing else.
The court said, okay, So you know that jurors are not permitted to read, watch, or listen to anything from any source concerning anything having to do with this case, correct?
Juror said, yes.
The court said, going forward, will you be able to follow that rule?
Juror said, yes.
The court said, you feel 100% confident about that?
Juror said, yes.
The court said, okay, you may step out.
Juror not present.
The court said, so is there an application that I replace the juror?
Mr. Kamraju said, can I have 30 seconds?
The court said, okay.
Counsel conferred.
Mr. Kamraju said, yes, Your Honor, we move to replace the juror. I think the fact that she disregarded an instruction that you'd given repeatedly at every day of trial is a sufficient basis to dismiss her. I think while the juror gave you an answer that she would not do that, that's the same answer that she would have given you during voir dire. She's already now proven that she cannot satisfy that obligation. And I think, well, it may be credible as it seems very difficult for me to believe that when you Google William J.E., that the only and sole thing that comes up is the fact that he has been charged in this case. And so even if she didn't read another article, we all know how Google works, the search results from Potluck. And so from the defense's perspective, a juror who's now disregarding an instruction that the court gives every day repeatedly, is one that should be excused. And the authority for that, as I said before, is United States versus Schult, among other cases.
Ms. Shrofa said, also, Your Honor, imagine if you run a search, and even if you just read one article, right? Would the first sentence have to say, William J. is charged in a case, and you stop right after that? It's very hard to sort of fathom how her answer pans out in a Google search. One could run a Google search. That's what I was concerned about in the response.
Mr. Finkel said, Your Honor, the government opposes that application and believes you have broad discretion here to deny it, and there are a few reasons why. The first is you can judge, Your Honor can judge, that juror's credibility. And what the juror told you is what she said happened. And if you perform a Google search, as we all, I'm sure, have, undoubtedly, that doesn't mean you click on an article. It doesn't mean you read articles. She said she Googled it. And it would be likely to Google William J. Yes. And if, for example, the press release from our office comes up as the first or second or third thing or news article saying William J. was charged in this case, there is no additional information that has been introduced into juror number 2's brain or certainly the jury overall's brain that is anything unknown to them. Because they know that William J. was charged. So do they know Yvette Wong was charged? Because it's on the indictment. They have the charging instrument. They have the allegations that the government has made in the indictment. The fact that they also have instructions about what to think about just one person being on trial, as opposed to other people being on trial. Your Honor is best positioned, and the only person who is positioned, to use Your Honor's discretion. Make a credibility assessment, and an assessment of this juror's ability to follow directions. The government's view is that she was candid with Your Honor, said she did it once this morning. Learned information that the jury already knows. The jury stopped right away. They are ready to renew their deliberations, and we think we should let them.
Mr. Kamraju said, there is one point I would like to make about that. William J.E. is charged in an obstruction count. That does not appear in the indictment. So we don't know what she read. But certainly if the title of an article says, William J.E. charged in an obstruction count, that is information that she would not have. And the difficulty is I don't see how you can ask for a question that doesn't get to that. So I do think that there is potential for information that could be out there that the juror does not know already. And I'm not sure that there's an easy way for the court to get there that doesn't trip up.
The court said, which is the next alternate who's up?
The law clerk said, alternate number 2.
The court said, okay, I think that it is appropriate that she be substituted, and I am going to excuse her here. We'll have to bring an alternate number 2. Where is he coming from?
The law clerk said, "He's on his way. He said he'll arrive at around 12:30.
The court said, my goodness. Okay, so if you'll have her brought back in.
Mr. Finkel said, Your Honor, it seems like Your Honor has made its decision, and so I won't go any further. Unless there's one additional piece I can be heard on.
The court said, you can talk.
Mr. Finkel said, If Your Honor would do what defense counsel suggested, to the extent this is still an open issue, which is, ask whether she learned about anything other than the fact that he was charged in this case, which is to say the specifics of the obstruction count. And for what it's worth, the facts underlying that obstruction count are in the indictment. They are described in the indictment, and also were described at trial. Bo Collins testified about it. It was about him, William J.E., trying to move money offshore when he found out that the money was seized. So those facts are in evidence. They are known. They are known to the jury. And it's certainly known to the jury that he's a co-conspirator and was charged as a co-conspirator. So that's the government's view. The government wouldn't oppose, and since we're going to, if we're really thinking about kicking her off and starting anew. See any harm in asking that additional question anyway. Maybe it will satisfy Your Honor.
The court said, but I did ask her whether she learned anything in addition to the fact that he had been charged.
Mr. Finkel said, right? So that's my point, I guess, really, is sort of in response to defense counsel. There's no information to suggest that she learned about the obstruction count. I don't mean to belabor this. Your Honor, if Your Honor has made a decision, you've made a decision. We can move on. I don't mean to intrude. Obviously the government, and I'm sure all the parties don't want to have to start deliberations anew. But if that's what Your Honor has decided, that's fine.
The court said, so just so you know, when I did the Google search, the first thing that comes up is the Department of Justice press release, and then is the SEC press release. So, and then of course there's an FBI.
Mr. Kamaraju said, they do a lot of press, Your Honor.
Mr. Finkel said, which is all about this case, obviously. But I understand Your Honor's point. And if Your Honor has decided to strike her, then the government understands that, and we'll continue.
The court said, okay, so let's bring her back. After I excuse her, I'm going to call the jurors and just to remind them that they are not to deliberate any further.
Mr. Kamaraju said, yes, Your Honor.
Juror present.
The court said, so I want to thank you for the weeks that you have put into this process, but I'm going to have to excuse you.
Juror said, okay.
The court said, thank you.
Juror said, sorry.
Juror not present.
The court said, all right, let's go back.
Mr. Kamaraju said, thank you, Your Honor.
In open court.
The court said, please have the jurors brought in.
Jury present.
The court said, members of the jury, you must cease your deliberations till I tell you that you can begin again. I'm hoping that I will be doing that shortly. You may go back.
Jury not present.
The court said, you may be seated. I want to know whether the attorneys would like me to retrieve any of the items that have already been delivered to the jury room.
Mr. Finkel said, the government doesn't believe that's appropriate.
Mr. Kamaraju said, I'm sorry, I didn't hear.
Mr. Finkel said, I said no.
Mr. Kamaraju said, I guess the only question would be whether the juror who was just excused left any notes on any of the documents. But other than that, we don't have an issue.
The court said, I'm going to have my staff collect various items and review them, and then if there are no notes, would you like me to have those items returned to the jury room?
Mr. Kamaraju said, that's fine with us, Your Honor.
Mr. Finkel said, yes. I mean, and with respect to, for example, Z9, the binders, I think they each have one. The government has no objection to taking her binder, and, to the extent she wrote on someone else's binder, that's fine. But those materials that the other jurors have, I don't think that they should be taken away from them. That's the government's point. That's all.
The court said, I'm not sure if I'm following what you're saying.
Mr. Finkel said, I'm sorry, Your Honor. So, for example, this morning the jury requested GXZ9, which is a binder. They each had their own binder. So juror number 2's binder, it would make sense we can take it out of the jury room. I understand. The rest of the jurors' binders, however, I think they should be allowed to keep.
The court said, so that assumes that they are separated. If they are, if everyone has their materials at their seat, that's fine. I don't know if they are in a pile. I just don't know what state they are in.
Mr. Finkel said, Your Honor's point is well taken.
The court said, okay. All righty. We'll let you know when the alternate arrives.
Mr. Finkel said, Thank you, Your Honor.
Recess.
The court said, please be seated. I'm told that alternate number 2 has arrived. The court security officer retrieved the GXZ9 binder and the GX417T exhibit, neither of which had any markings. Also retrieved were juror number 2's 2 steno notebooks, as well as her copy of the indictment and the jury charge. I will provide a fresh copy of the indictment and the jury charge to the alternate who will be substituting, and will be returning to that alternate the steno notebooks that he created. I'm first going to ask the alternate to come out so that I can question him as to whether he has followed my rules.
Juror present.
The court said, please be seated. Your alternate number 2.
Juror said, yes.
The court said, you may recall that I have repeated certain rules throughout the trial. One is that you are not to discuss the case with the other jurors or with anyone else. Another is that you're not to permit anyone to discuss the case in your presence. Have you complied with those rules?
Juror said, yes, I have.
The court said, in addition, I have instructed all of the jurors to not read, watch, or listen to anything from any source that touches on the subject matter of this trial. You remember that?
Juror said, yes, I do.
The court said, have you complied with that?
Juror said, yes, I have.
The court said, all righty. I am going to be substituting you in for juror number 2. So you may move to the next seat over and I'll have the jurors come in.
Jury present.
The court said, please be seated. Members of the jury, alternate juror number 2 is now juror number 2. This means that you're going to have to wipe the slate clean. You are to disregard discussions that you previously had with the original juror number 2 and recommence anew, completely freshly. So don't refer back to things that were said when the prior juror number 2 was part of the jury. You must start from square one. Everybody understand?
The jury said, yes.
The court said, okay. Everybody says yes. All right. You may commence your deliberations.
At 12:40 p.m., the jury retired to deliberate.
The court said, please be seated. I will let you know if I hear from the jury. Is there anything that you want to let me know?
Ms. Murray said, Your Honor. I just wanted to inquire whether the court would be inclined to let the jury stay later than 5 today if they would like to continue their deliberations.
Court said, oh yes.
Ms. Murray said, thank you.
The court said, all righty. I'll let you know.
Recess pending verdict.
The court said, please be seated. Please have the jurors brought out.
Mr. Kamaraju said, I just had a question, Your Honor. I was wondering if we're going to do what Judge Stein did earlier in the Menendez case. And just say to the jurors or send them a note that says something to the effect of, we plan to break as normal at 5 o'clock. If you want to stay later than that, send us a note or something like that.
The court said, I'm going to tell them that directly.
Mr. Kamaraju said, okay.
Jury present.
The court said, you may be seated. Members of the jury, I just wanted to let you know that if you'd like, you're welcome to stay late this evening. If that's what you'd like, you'll just send me a note to that effect. Alrighty. If you need to ask me a question, of course you'll have to send me a note. But let me tell you that. Of course I would have dinner brought in for you. Okay.
Jury not present.
The court said, I'll let you know if I hear from them.
Ms. Murray said, thank you, Your Honor.
Recess pending verdict.
The court said, could we have the jurors brought in, please?
Jury present.
The court said, "Please be seated. Members of the jury, I received your note at 3:45 p.m. which states, 'We, the jury.' Unfortunately, the jury is unable to stay past 5 p.m. for deliberations. It's signed by the foreperson and dated today's date. So you've come to the end of your work for today. You'll return on Monday to continue with your deliberations. So all deliberations must cease starting now. And when you return on Monday, you'll recommence. So it's the same old rules as before. Don't discuss the case amongst yourselves or with anyone else. Don't permit anyone to discuss the case in your presence. Don't read, watch, or listen to anything from any source that touches upon the subject matter of this case. You will recommence deliberations when you're all in the jury room and the foreperson says it is time to recommence. So thank you and see you back on Monday. Have a good weekend."
Jury not present.
The court said, "Please be seated. Is there anything from the parties?"
Mr. Kamaraju said, "Not from the defense, Your Honor."
Ms. Murray said, "I just wanted to confirm what time you would like the parties to be here on Monday morning, Your Honor."
The court said, "So I see no need for you to come to the courtroom at any particular time. We'll let you know when we get a note."
Mr. Kamaraju said, "Thank you, Your Honor."
Ms. Murray said, "Thank you, Your Honor."
The court said, "Have a good weekend."
Adjourned to July 15th, 2024 at 9 a.m.